Welcome. You've come to us for a thorough analysis of one of the most high-profile, complex, and widely scrutinized criminal cases of the 21st century. This is a tragedy that really unfolded in real time.
It absolutely did, and it went
Yeah.
far beyond the courtroom, becoming this global media phenomenon.
Exactly. We are focusing today on the 2008 murder of Travis Alexander in Mesa, Arizona, and of course, the subsequent legal proceedings involving Jodi Arias.
The amount of media coverage was it was something else.
It was unprecedented. It turned a horrific local murder trial into something that millions of people felt they had to watch day in and day out for years.
And as we start this detailed exploration of the source material, it is so essential that we foreground the terrible reality of this case.
Yes.
And that is the violent and brutal loss of Travis Alexander's life. The goal of this analysis isn't just to, recount the events. It's to systematically examine the evidence, the shifting narratives that Arias presented, the very contentious trial proceedings, and maybe most importantly, the profound and frankly disturbing social and media impact this all had.
That's right. To really grasp the sheer complexity and the eventual chaos of this case, we need to go step by step. We'll begin by grounding ourselves in the personal histories of Travis Alexander and Jodi Arias, then move chronologically through the physical evidence left at the scene, the various conflicting accounts she gave, and then into that courtroom battle between premeditation and self-defense.
And finally, the incredible social ripple effects that really define the whole thing.
Let's start with the victim, Travis Alexander. He was born in Riverside, California in 1977.
Our sources show he faced some pretty significant challenges early on. He moved in with his paternal grandparents at only 8 years old.
And it seems that sense of family obligation was a big part of his life. After his father died in 1997, his 7 younger siblings also went to live with his grandmother.
Professionally, he was doing very well. Highly successful as a salesman and motivational speaker for prepaid legal services, or PPL.
He was also a very devoted member of the Church of Jesus Christ of Latter-day Saints, the LDS Church. He'd served a mission, had deep ties to that community.
But there was this surprising duality to him, wasn't there?
The stand-up comedy.
Exactly, under the alter ego, Eddie Snell.
That dual identity is fascinating. The motivational speaker and devout church member who also did comedy and, according to a friend, admitted to being in fights a lot before he joined the LDS Church.
It really hints at a complex personality, which, as we'll see, became a critical point when his character was essentially put on trial.
And then on the other side, we have Jodi Arias, born in Salinas, California in 1980.
Her educational path was a little less structured. She dropped out of high school in the 11th grade.
And like Alexander, she also ended up in direct sales with PPL after working various odd jobs, and she had aspirations of becoming a professional photographer.
And their paths crossed in September 2006.
At that PPL work conference in Las Vegas.
Yes, and the sources confirmed their connection was immediate and very intense.
It became intertwined with his faith almost right away. Arias converted to the LDS Church shortly after they met.
And Alexander himself baptized her in November of 2006.
They officially started dating in February 2007. The relationship, which went on for about a year and a half, was often long distance.
Right, back and forth between Arizona, where he was, and California, where she eventually moved back to live with her grandparents.
But the volatility was legendary, according to people who saw it up close.
Alexander's friends, many of whom ended up testifying, had a very strong, very negative opinion of Arias pretty much from the beginning.
They voiced serious concerns. They called the relationship unusually tumultuous and were worried specifically about her behavior.
Her obsessive behavior.
What makes it so difficult to understand from the outside is just how complex their connection was, even after they'd supposedly broken up.
That's a crucial point. The sources are clear that even when Alexander was dating other women, he and Arias would continue to engage in sexting and, this very intense private communication.
It suggests a powerful, maybe even mutually destructive bond that just kept going no matter what their official relationship status was. That context is absolutely critical.
That complex and volatile background really sets the stage for the catastrophic events of June 4, 2008. We have to now turn to the crime itself and the physical evidence that ultimately dismantled every story Arias later told.
On that afternoon, Travis Alexander was murdered in his Mesa home while he was in the shower. The brutality of it, as documented by the medical examiner, is it's almost unbelievable.
And this violence, it formed the absolute cornerstone of the prosecution's case for premeditation and depravity.
The The medical examiner, Dr. Kevin Horn, provided some truly staggering testimony. He detailed the extent of the injuries.
Alexander suffered 27 stab wounds.
27.
He had a severely slit throat. It severed his jugular vein, the carotid artery, and his trachea. And on top of all that, a single gunshot wound to his forehead.
And crucially, he had defensive wounds on his hands,
Which clearly showed he fought back. Desperately.
Dr. Horn's testimony also went into the sequence of the attack. He suggested that Alexander might have already been dead or at least incapacitated when the gunshot happened.
And he noted that some of the stab wounds on his back were relatively shallow.
Which suggests a frenzy, a rage, not a single clean strike. The sheer overkill indicated this tremendous anger.
The timeline of the discovery is also critical because it gave Arias time to cover her tracks. Alexander missed a really important business conference call on the evening of June 4th.
And the very next day, June 5th, she's 800 miles away.
That's right. She met a man named Ryan Burns in West Jordan, Utah. She was there for PPL business meetings.
And Burns' testimony became incredibly significant. He noticed two major things.
Two physical changes, yes. First, Arias, who had been blonde, now had newly dyed dark brown hair. And second, she had visible cuts on her hands.
And when he asked about the cuts,
She had an explanation ready. She claimed she'd cut herself on broken glass while working at a restaurant called Margaritaville.
a story that was very quickly proven to be a lie. A detective later testified that no such restaurant even existed in the area.
So that established her willingness to fabricate details, immediately after the murder.
And the logistics of her travel, I mean, that's perhaps the most damning early evidence of intent.
It really is. She rented a car in California, drove to Arizona, murdered Alexander, and then drove all the way up to Utah, and then back down toward California.
When she returned the rental car on June 7th, the odometer showed she'd traveled approximately 2,800 miles in just a few days.
And there's more. The rental clerk noticed the car was missing its floor mats and had red stains on the seats.
Now, the police couldn't analyze those stains because the car was clean before they could get to it.
But the fact that the mats were missing, and she traveled so far, it suggests a very methodical effort to sanitize that vehicle right after a very violent crime.
It wasn't until June 9th, 5 full days after the murder, that his body was discovered.
A group of his friends got concerned. They hadn't been able to reach him. They knew how devoted he was to his work.
So they went to his house. His roommates thought he was just out of town.
It was the friends who found a key, entered his locked bedroom, and then they found him in the shower.
And the 911 call made by those friends immediately focused all suspicion on Arias.
The dispatcher asked if anyone might have wanted to harm him.
And they instantly named her. No hesitation.
They told the police that Alexander had confided in them that she was stalking him, that she was accessing his Facebook account without permission.
And that she'd even slashed his tires. This was the first real hint of that obsessive behavior that would become the core of the prosecution's case.
Which brings us to the truly undeniable forensic proof.
The damaged digital camera?
Police recovered Alexander's recently purchased digital camera. They found it damaged inside the washing machine.
But in an incredible stroke of luck for the investigation, they were able to recover deleted images from the memory card.
And the timeline captured by those recovered photos is just. It's utterly crucial. It establishes a definitive sequence of events that places her at the scene and details the moments right up to the murder.
The photos showed Arias and Alexander in some sexually suggestive poses, taken around 1:40 p.m. on June 4th.
And then the final photograph of him alive, in the shower, timestamped at 5:29 p.m. that evening.
And the final shocking piece of photo evidence, images taken moments after 5:29 p.m. showed an individual believed to be Alexander on the bathroom floor, already profusely bleeding.
It's evidence that directly contradicts any story claiming she wasn't there or that the timeline was somehow fuzzy. It's concrete.
And on top of all that, the DNA evidence. A bloody palm print was recovered from the bathroom hallway.
And that print contained DNA from both Alexander and Arias.
So that conclusively places her at the scene, covered in his blood at the time the murder occurred.
The combination of that camera timeline and the DNA made it nearly impossible for her to mount any successful defense that denied she was involved.
Despite this mountain of evidence, Arias, who was indicted for first-degree murder in July 2008 and arrested, she repeatedly changed her story.
This progression of conflicting alibis is such a critical part of the case. It undermined her credibility, long before she ever took the stand.
Let's track that progression. Her initial story, the one she told police, was a complete denial.
Right. She claimed she wasn't in Mesa at all on the day of the murder, said she'd last seen him back in March 2008.
And that denial just crumbled immediately once they found the camera and the DNA.
So then came the second narrative, a major pivot. She claimed that two masked intruders had broken into the home, murdered him, and attacked her in the process.
This was her attempt to explain her DNA and her presence at the scene.
But it made no logical sense. There was no sign of forced entry, and the attack was so deeply personal.
It wasn't until 2 years after her arrest, after she had already tried out two provably false stories, that her third and final narrative emerged.
Self-defense.
Yes. This claim alleged that she was a victim of domestic violence and had killed him only after he attacked her in a sudden, violent rage.
And this self-defense plea, it became the sole foundation of her entire defense strategy during the trial.
The pre-trial phase was just full of delays and significant conflict. It really foreshadowed the procedural chaos that was coming.
In April 2009, there was a motion to disqualify the Maricopa County DA's office, though it was denied. But the biggest conflict was really about evidence disclosure.
The defense was constantly fighting to get electronic communications from the prosecution,
Initially, the prosecution claimed there were no text messages from Alexander available.
which turned out not to be true. They were later ordered to turn over several hundred messages.
And the email evidence was even more concerning. A police detective initially claimed there was nothing of significance in Alexander's emails, suggesting they'd barely been reviewed.
But then, approximately 8,000 emails were eventually turned over to the defense.
The sheer volume of that and how late it was disclosed, plus the prosecution's initial claim that there was nothing available, it raised really serious questions about the fairness of the discovery process.
The trial finally began in December 2012 with Judge Sherry K. Stevens presiding, and it attracted immediate national attention.
And even the jury selection process started off contentiously.
Arias's defense attorneys argued that the prosecutor, Juan Martinez, was systematically excluding potential jurors based on race and gender.
Specifically targeting women and black people.
Martinez denied it, of course, said race and sex were irrelevant to his criteria, and ultimately Judge Stevens ruled that the prosecution hadn't shown any bias.
So when the guilt phase finally began in January 2013, the jury was presented with two fundamentally opposing views of what happened on June 4th.
The prosecution argued for cold, calculated premeditation,
while the defense argued for reactive self-defense driven by long-term abuse.
The prosecution's case painted Arias as this jealous, manipulative person who, driven by Alexander's desire to end their relationship for good, carefully planned his murder.
They had to prove it wasn't a spontaneous outburst, but a deliberate, considered act.
And to support that idea of premeditation, they laid out a specific sequence of her planning.
They alleged she staged a robbery at her grandparents' home, where she was staying, specifically to steal the .25 caliber handgun used in the shooting.
And the fact that it was a less common .25 caliber weapon suggested a deliberate choice and preparation.
And think about the meticulous effort of her travel. The prosecution emphasized that she bought a gas can and gas before the trip,
which they argued was an attempt to avoid using her credit card at gas stations, to cover her digital tracks on that 2,800-mile round trip.
Every action she took was framed as evidence of this covert, planned mission.
They also used Alexander's own words, citing a text message where he called Arias evil to show his fear and distrust.
And the prosecution reinforced his character by calling several of his other girlfriends as rebuttal witnesses.
And they all testified consistently that they had never seen him exhibit anger issues or violent behavior,
which was aimed directly at discrediting the defense's entire abuse narrative.
That abuse narrative, though, was really the only thing Arias had left.
Her defense team argued that Alexander was indeed violent and abusive, and that she only acted in a desperate attempt at self-preservation.
Their main scenario was that he lunged at her in anger after she accidentally dropped his camera, and that's what triggered her defensive response.
A huge part of this defense was Arias's own time on the witness stand.
She testified for an astonishing 18 days.
A duration that experienced criminal defense attorneys called unprecedented.
And she used that time to detail not only alleged abuse by Alexander, but also abuse she said she suffered from her parents, trying to create this comprehensive history of trauma.
The testimony often got into graphic and highly controversial territory, especially about their sex life.
The defense played a phone sex tape where Alexander described wanting to tie her up and sodomize her.
And her response, captured on the tape, became famous. That is so debasing, I like it.
Arias also used her time on the stand to allege that Alexander harbored pedophilic desires and that she had been trying to help him manage them.
It was a clear attempt to sully his reputation and imply he had a dangerous character.
To physically ground the abuse claim, the defense had Arias hold up her left hand in the courtroom to show her crooked ring finger.
She alleged that Alexander had broken it during an earlier argument, presenting it as physical proof of his violence.
The defense also tried to introduce electronic communications to challenge his character. They alluded to emails between Alexander and his friends Chris and Sky Hughes.
And these were highly contentious. The judge ruled them inadmissible as hearsay, meaning they couldn't be authenticated, but some of the alleged content became public through court filings.
One of the most inflammatory details was an email where Alexander allegedly responded to a friend's concerns about Arias by saying, "I am a bit of a sociopath."
Now, legally, the jury never saw that. But it instantly became part of the public narrative, used to paint Alexander as having this dark, potentially violent side.
However, his friend, Chris Hughes, later testified that he and his wife believed Arias had manipulated them and that they'd had a falling out with her after catching her eavesdropping on their private conversations with Alexander on 2 separate occasions.
So because the physical evidence so overwhelmingly placed Arias at the scene, the battle just shifted. It moved to the psychological realm.
Which led to this profound war of the experts, all designed to interpret her state of mind.
The defense called psychotherapist Alice Laviolette, who specializes in domestic violence.
And Laviolette testified that Arias fit the profile of a domestic abuse victim, explaining that most victims feel shame and humiliation, which often leads to lying about the abuse.
It was an attempt to justify Arias's rapidly changing stories.
Next was psychologist Richard Samuels. His testimony lasted for almost 6 days.
Samuels suggested that Arias was suffering from acute stress at the time of the murder, leading to a fight-or-flight response and resulting in memory gaps.
And he diagnosed her with post-traumatic stress disorder, or PTSD.
That is such a critical distinction. A PTSD diagnosis supports the defense narrative that she was so traumatized that when he lunged at her, she snapped into a defensive survival mode, acting instinctively, not with premeditation.
A juror even asked him if that fight-or-flight response could happen if the murder was premeditated.
And he maintained, "Is it possible? Yes. Is it probable? No."
The prosecution's rebuttal was forceful, and it specifically targeted the credibility of those defense experts.
Prosecutor Juan Martinez aggressively attacked Samuels, even accusing him of bias, by citing Samuels' prior admission that he felt compassion for Arias.
And it's important for you to know that the Arizona Court of Appeals later specifically castigated Martinez's methods of questioning Samuels as improper conduct.
The prosecution's key rebuttal witness was clinical psychologist Janine DeMart. She testified that Arias was not a victim of abuse and did not have PTSD.
Instead, DeMart offered a different psychological framework. She diagnosed Arias with borderline personality disorder, or BPD.
And that diagnosis of BPD fundamentally changes the entire narrative.
Unlike PTSD, which supports trauma, BPD is characterized by severe instability in mood, self-image, and behavior.
It often includes an intense fear of abandonment, unstable relationships, and tendencies toward idealization and then devaluation. The exact traits the prosecution used to paint Arias as a jealous, controlling manipulator who could snap when faced with rejection.
This expert disagreement also got very technical, centering on specific psychological tests.
Right. Samuels relied on the MCMI, which is often geared toward diagnosing personality disorders in clinical settings. DeMart, on the other hand, relied partly on the MMPI.
The defense then called another psychologist, Robert Geffner, who supported Samuels' original claim, arguing the test pointed toward an anxiety disorder from trauma.
And crucially, Geffner challenged DeMart's choice of the MMPI, suggesting it wasn't the best tool for diagnosing BPD, which created this technical argument over which diagnostic test was superior.
The prosecution got the final say, bringing in forensic neuropsychologist Jill Hayes, who disputed Geffner's claim, reinforcing the prosecution's challenge to the entire defense psychological framework.
This war of the experts really showed how subjective even seemingly scientific diagnoses can be when you're filtering complex human behavior.
In the closing arguments, Martinez was just relentless. He urged the jurors not to be manipulated.
He redisplayed those horrific crime scene photos and repeated Alexander's evil text message. His central point was that the sheer number of wounds demonstrated an intent to kill, not a frightened reaction.
The defense, while acknowledging how emotional the case was, argued the jury needed to look past any personal dislike they had for Arias.
They stressed that the prosecution's theory of cold, calculated premeditation just didn't hold up. They cited her behavior appearing on security cameras, saving receipts for the gas cans, even spending the night at his house before the killing.
They argued those actions were inconsistent with a covert mission to commit murder.
But Martinez had the dramatic final word in his rebuttal. He focused solely on the brutality, emphasizing the number and variety of the wounds, which he characterized not as a fight for survival, but unequivocally as a slaughter.
After nearly 4 months of intense testimony, the case went to the jury. They were instructed they could find her guilty of first-degree murder if they unanimously agreed on either premeditation
or felony murder.
And this is a key legal distinction that often gets missed. Premeditation means it was planned.
Right. And felony murder means the killing happened during the commission of another felony. In this case, the state argued it was murder committed during an assault or attempted sexual assault.
The jury didn't have to agree on which type, just that one had occurred.
On May 8, 2013, after just 15 hours of deliberation, the verdict was returned. Jodi Arias was found guilty of first-degree murder.
And the jury had to specify the basis. All 12 found her guilty of first-degree premeditated murder, completely rejecting the self-defense claim.
Additionally, 7 of the 12 jurors also found her guilty of felony murder.
The family of Travis Alexander hugged and smiled as the verdict was read, and the crowds outside the courtroom just erupted in cheers.
The conviction instantly moved the case into the penalty phase, where the prosecution was seeking the death penalty.
Before that could happen, the state had to prove the murder met the standard for being an aggravating factor, which meant proving it was cruel, heinous, or depraved.
This aggravation phase began on May 15, 2013. The defense offered brief arguments, suggesting Alexander's adrenaline might have prevented him from feeling prolonged pain.
But Martinez's presentation was focused entirely on demonstrating the protracted nature of his suffering. He showed the crime scene photos one last time.
And then he engaged in this very dramatic pause, standing in silence for 2 minutes, arguing this was how long Alexander suffered before he died.
That tactic clearly had an impact. After less than 3 hours, the jury unanimously determined that Arias was eligible for the death penalty.
Then came the penalty phase, where the jury weighed mitigating and aggravating factors to decide between life and death. It began with powerful victim impact statements from Alexander's family.
They all urged the jury to impose the death penalty.
A surprising turning point came on May 21st, when Arias gave her allocution a formal statement before sentencing.
She pleaded for a life sentence. This was a complete reversal of what she'd told a TV reporter right after her conviction,
where she had very cavalierly said she preferred the death penalty.
She explained to the jury she lacked perspective and had changed her mind to spare her family the pain of her execution.
And she made these specific public promises. She held up a white T-shirt with "Survivor" on it, promising to sell them and donate the proceeds to domestic abuse victims. She also vowed to donate her hair to Locks of Love.
Despite that plea, the first penalty phase ended in a hung jury on May 23, 2013.
The judge had to declare a mistrial for that phase. The jury revealed they'd reached an 8-4 decision favoring the death penalty.
The jury foreman later spoke about the enormous pressure, calling the responsibility overwhelming. He said the panel felt mentally and emotionally exhausted and felt like they had failed.
The county attorney, Bill Montgomery, immediately announced plans for a sentencing retrial to get a new jury just to decide the penalty.
This was met with pushback from the defense. They publicly stated that if the state's own expert was right about her having borderline personality disorder, then the county attorney was seeking the death penalty for a mentally ill woman with no prior criminal record.
The sentencing retrial began over a year later, in October 2014, with a completely new jury.
Interestingly, during this retrial, some technical evidence was re-examined. Mesa police experts admitted that Alexander's laptop had contained viruses and pornography, which was contrary to the more sanitized testimony from the first trial.
The second jury began deliberations in February 2015, but on March 5th, they too deadlocked. A second mistrial for sentencing.
This jury stalled at an 11-1 vote, again favoring the death penalty. Just a single holdout juror prevented it.
The consequence of 2 hung juries was monumental. The death penalty was legally off the table.
The decision reverted back to Judge Stevens, who now had only 2 options left: life without parole or life with the possibility of parole after 25 years.
On April 13, 2015, Judge Stevens sentenced Arias to life imprisonment without the possibility of parole.
By this point, the whole process had cost taxpayers an estimated $3 million. Arias was also ordered to pay over $32,000 in restitution to Alexander's siblings.
And currently, she's incarcerated at the Arizona State Prison Complex, Perryville. She was initially in maximum security, but has since been downgraded to medium security.
So now we have to shift our focus to the truly unique and, frankly, unsettling aspect of this case, the atmosphere surrounding the trial.
It became a defining characteristic, and as the appellate courts noted, it raised serious questions about the fairness of the judicial process itself.
The Associated Press famously described it as a circus and a runaway train. It exploded into a worldwide sensation, largely because the trial was broadcast on a live, unedited web feed.
That technology, used for the first time on such a scale, spawned a virtual cottage industry of commentary and talk shows. The trial became a live, daytime soap opera.
This constant, unfiltered coverage just fueled a frenzied public engagement. The commercialization was stark. The cable network HLN openly boasted about their massive ratings, ranking #1 during Arias' emotional plea for her life.
The trial became entertainment.
It did, and the atmosphere was so charged that public figures were openly undermining the presumption of innocence. The governor of Arizona, Jan Brewer, publicly told reporters she believed Arias was guilty before the verdict was even delivered.
That kind of high-level opinion undoubtedly added immense pressure to the whole process.
And this transformation into a spectacle had tangible negative effects on the legal proceedings. The jury foreman noted after the trial that Arias' 18 days on the stand under that media glare ultimately hurt her defense.
It damaged her credibility with the jury.
The role of social media in this trial also set an alarming precedent for high-profile cases. It demonstrated new levels of intimidation and outrage.
Consider the experience of the defense witness Alice Laviolette, the psychotherapist who testified Arias was a victim of abuse.
She faced extreme public backlash. Over 500 negative reviews of her yet-to-be-released book appeared instantly on Amazon.com, calling her a fraud. A retired judge publicly called it the electronic version of a lynch mob.
And the threats weren't just digital. Attorneys and witnesses received actual death threats. This online ridicule and the real danger it created, it could fundamentally affect a witness's willingness to even testify.
Social media was actively trying to influence the outcome. The lead defense attorney, Kirk Nurmi, was relentlessly attacked online.
In one egregious example, someone digitally superimposed his face onto a crime scene photo of Alexander.
That goes so far beyond criticism, it's psychological warfare against a defense team.
And perhaps most alarming was the targeting of the jury. The holdout juror in the second retrial, the one person who prevented the death penalty, received threats.
Her personal information, name, address, phone number, was published online, doxed.
The county attorney's office had to release a statement demanding that the attacks on her cease.
And adding this surreal element to it all, Arias' own brother started selling her jailhouse artwork on eBay.
He claimed the profits were for family travel expenses and better food for Arias in jail. It just underscored how much the Arias name itself had become a brand.
After her conviction, her attorneys filed appeals, arguing that prosecutor Juan Martinez's highly visible and aggressive actions were inappropriate and fueled the media frenzy, biasing the trial.
And the Arizona Court of Appeals ruling on this in March 2020 is exceptionally significant. While they upheld the conviction, they delivered this stinging rebuke to the prosecutor.
They acknowledged his egregious and self-promoting misconduct. They explicitly said he acted improperly.
The court detailed his inappropriate behavior with the media, his seeking the spotlight, and his overstepping boundaries and questioning experts. But the conviction was upheld.
Because the appellate court determined she was convicted based upon the overwhelming evidence of her guilt, specifically citing the camera timeline and the DNA. The Arizona Supreme Court later declined to review the case.
So this leaves us with a truly complicated legacy. A conviction secured by irrefutable forensic evidence, yet forever tainted by acknowledged prosecutorial impropriety, 2 procedural failures in sentencing, and a media spectacle that physically threatened the safety of everyone involved in the justice system.
To synthesize the major points of this analysis, we've seen a case that was defined by powerful forensic proof, the camera timeline, the bloody palm print, that conclusively proved her guilt and contradicted her shifting narratives.
Yet that definitive outcome was followed by this extraordinary chaos. Acknowledged misconduct by the prosecutor, 2 mistrials in the penalty phase, and a trial environment where public outrage, amplified by social media, turned the courtroom into a physical and digital danger zone.
So, if we look at the complete picture, we have overwhelming evidence of guilt, but a legal process so marred by public opinion and procedural error that the appellate court had to specifically condemn the prosecutor's egregious conduct.
Which leads us to a final provocative question for you to consider.
How does the intense, constant visibility of a case where attorneys, witnesses, and even jurors face extreme public scrutiny and threats affect the integrity and fairness of the justice system, particularly in these high-stakes capital murder trials? We appreciate you engaging with this detailed examination of the source material. Thanks for listening.